In Ontario, the government is proposing to make strict driving laws even stricter, but not with respect to what you can do on the roads, rather what will happen to you if something occurs on the roads. As a result of two crashes, one of which resulted in a fatality involving the same driver, who was only 18 years old, and who had hit Premier Doug Ford's vehicle, so there's a little bit of a personal issue going on here. The government is suggesting an immediate license suspension for people who are charged with these driving offenses, lifetime driving bans, and permanent revocation of licenses after multiple convictions for serious offenses. There's a couple problems with this. Number one, there are already provisions in place to indefinitely revoke somebody's driver's license if they commit a serious driving offense in Ontario. Number two, the courts have already found in Alberta that if the government imposes indefinite suspensions on the basis of somebody being charged until their case is resolved in court, that essentially constitutes a de facto bail condition and is unconstitutional. The province doesn't get to make criminal law. They can make road and safety law, but if they're tying it to a criminal charge, it is effectively creating or supplementing the criminal law, which a provincial government is not allowed to do. Only the federal government in Canada can enact criminal laws. And the other suggestion that they're having is harsher penalties for people who flee the scenes of accidents, including incarceration and vehicle seizure. And on the one hand, vehicle seizure is a possibility under provincial regimes because of the civil forfeiture regime. Having it tied to a conviction, again, potentially creates a supplementing of the criminal law, especially if you're using a carceral sentence in context of applying a consequence to a criminal conviction under a provincial administrative scheme. It's one thing to impose a driving ban. Pretty much every province, if you're convicted of certain driving offenses, will impose an automatic driving ban provincially, notwithstanding what the courts may do, including offenses where there are already mandatory minimum driving bans from the courts. But that doesn't mean that you can go beyond that and add jail in circumstances where jail might not be appropriate. The offense of fleeing the scene of an accident in the Criminal Code of Canada is an offense that doesn't have a mandatory minimum sentence. That means a person can get anything from a conditional discharge, or an absolute discharge, all the way up to a jail sentence. If the provincial government steps in and imposes a jail sentence on somebody who maybe gets a discharge or a suspended sentence for an offense of fleeing the scene of an accident, they're supplementing the criminal law, and they're using a sort of blind policy to impose jail sentences on people where the courts have already determined jail sentences aren't appropriate or consistent with the principles of sentencing, which includes deterrence, both general and specific, rehabilitation, and promoting a sense of responsibility in individuals. So it's unlikely that if they do create automatic jail provisions for people who are convicted of fleeing the scene of an accident, that there would ultimately be a successful law, because it would be constitutionally challenged and struck down. But keep an eye out. These are the types of laws that are being proposed for driving in Ontario.